morning, respected judges, participants, and audience. Myself, Ikra Siddiqui, and I will be the courtroom officer for this semi-final round. Judges, please take note. The petitioner with team code CNL 24, where Speaker 1 has taken a time of 21 minutes. Speaker 2 has taken a time of 20 minutes. And the team totally opted 4 minutes for the rebuttal. Where side, respondents with team code CNL 30, where Speaker 1 has taken time of 21 minutes, Speaker 2 has taken time of 21 minutes, and the team totally opted 3 minutes for the sir rebuttal. Now, I would like to run through a few quick rules for the participants. You cannot reveal which institution you represent at any time during the round. Participants are to remain seated at all times except for the one who is pleading. Participants cannot use any sort of unparliamentary words and are requested to maintain the decorum of the court. Participants are allowed to communicate with their teammates after seeking the permission from the judges during the round. The speaker is not allowed to discuss the subject with the researcher, but the researcher is allowed to pass chits to the speaker after seeking permission of the courtroom officer. Moving forward with the structure of the competition, there will be 3 stages in this competition, that is, applicant's pleading, respondent pleadings, and rebuttal or sir rebuttal stage. Each team shall have a maximum of 45 minutes, of which 25 minutes is the time allotted to each speaker. This includes the rebuttal and sir rebuttal of the proceedings. At any point of the time, the judges may seek clarification from the teams and also question them on any part of the arguments presented by the participants. However, the time will not be paused during such times. If the team exceeds the allocated time, there will be a negative marking. Now, we will begin the round after taking the permission of the judges.
Check. The council seeks permission to address the bench collectively as your lordships. Much obliged. This is Council 1 appearing on behalf of the petitioners in the case of the Democratic Reform Project versus the Union of Bharat Nadu. Your lordships, this is Council 1 appearing on behalf of the petitioners, and Council 1 will be addressing the first 3 issues, and my co-counsel will be addressing the 4th and the 5th issue. Your lordship, the first issue in regards to the current case is whether the writ petition filed before the Honorable Supreme Court of Bharat Nadu is maintainable. Your lordships, the council will argue this issue in 2 folds. Firstly, the petition filed before the Honorable Supreme Court of Bharat Nadu is a public interest litigation, and secondly, the petitioners has the locus standi to file the petition. Your lordships, the current writ petition filed before the Honorable Supreme Court is of the nature of public interest litigation. A bill is not statutorily defined anywhere. Your lordship, in the case of Janata Dal versus H.S. Chaudhary, which has been cited in citation 1 of the memorial, the Honorable Court has held that the expression bill means a legal action started in a court of law for enforcement of public and general interest. Your lordship, In such cases, in case the fundamental rights of the citizens have been infringed or affected in large, then this shall be considered as a bill, and the petitioner shall have the locus standi to file this particular petition. If the bench is satisfied, the council shall move to the second issue framed in the case.
Before that, tell us the facts.
Indeed, Your Lordships.
Hello. Ma'am.
Your Lordships, in the current case, Bharat Nadu is a diverse and a populous nation. Following the increase of the crime rates and lack of resources, the government, in collaboration with BNIML, developed an AI tool named Yugadrishti. Your Lordship, this particular tool helps in predicting recidivism. Your Lordships, by analyzing historical crime data compiled by the Criminal Bureau Investigation of Bharat Nadu and is applied in 3 cases, that is, detention, bail hearings and sentencing. The AI is known to have biases despite high accuracy. Your Lordship, the Democratic Reform Project is an NGO that has challenged the constitutional validity of the AI and other laws that is being framed for data collection in violation of Article 21 and 14, Your Lordships. Your Lordships, the Council seeks permission to move on to the second issue. Your Lordships, the second issue that is being framed in the current case is whether the use of AI algorithm in pre-trial detention, bail hearing and sentencing violate the right of fair trial under Article 21 of the Constitution of Bharat Nadu. Your Lordships, fair trial obviously means that trial before an impartial judge, an impartial prosecutor, and in an atmosphere of judicial calm. Your Lordship, understanding and dissecting the various facets of Article 21 and the Council shall proceed to substantiate as to how each and every facet of Article 21 has been violated in the current case. Your Lordships, the various facets are presumption of innocence, impartial tribunal, adversarial system, reformative justice, lack of prejudice and biases. Your Lordships, the Council will argue this particular issue in 6 folds. Firstly, the system of adversarial system. Your Lordship, the state of Bharat Nadu follows an adversarial system, which means both the prosecution as well as the defense should be having equal opportunity to present their cases, Your Lordships. However, according to this system, each and every party has to be equally equipped regarding the case. Your Lordship, this particular principle has been reiterated in various cases, like Mrs. Kalyani Bhaskar versus Mrs. Sampuran. Lordship, however, considering the present case, the AI algorithm is an undisclosed blindsliding judiciary. The accused and the public is working on the mechanism which is being mentioned in para 14 of the moot proposition, Your Lordships. Your Lordship, hence any decision that is being made on the basis of the risk reports that is being finally predicted by the AI, that is the Yugadrishti in the present case, is not in compliance with the adversarial system. Your Lordships, moving on to the second fold of the argument and the most important fold, that is the lack of prejudice that is to be guaranteed. Your Lordships, lack of prejudice is seen in compliance of fair trial. This connotes impartiality, neutrality and lack of biases. Your Lordships, in the case of Willie Sandley versus State of Madhya Pradesh, which has been tagged in tag 39 of the compendium, it states that the object of criminal procedure code in the country itself is to assure the accused a right to fair trial. Your Lordships, in the present case, there are 2 kinds of prejudices that is arising. The 2 prejudices are, firstly, the collection of data procedure is not reliable. To substantiate the same, the councils have tagged a report in R4 of the compendium, Your Lordships. Your Lordships, the data collection is tag R4 of the compendium, Your Lordships. Your Lordships, the collection of data is solely done by the... Your Lordships, the tag has a variable color which states R4. R4, Your Lordships. R4. It's in the peach tag.
Correct. Go ahead.
Your Lordships. Your Lordships, so the data collection process is conducted by the Crime Bureau of Bharat Nadu, which has been mentioned in para 12 of the moot proposition, which is in parametria with the NCRB of India. Your Lordship, in that particular report, it has been illustrated as to how unrepresentative, biased, and non-exhaustive are the data that has been collected by the NCRB. Your Lordship, the second parameter is that the AI is using the parameters and assigning the parameters in such a way that is prone to be prejudicial. Your Lordships, the primary purpose of an AI is to eliminate human bias. But what is to be devolved and pondered upon is, are we actually eliminating human bias, or are we just camouflaging it with technological bias? Your Lordships, to substantiate the same, the Council for Petitioners have attached a report in R2 of the compendium, which states that how such recidivism technological models used in other countries are prone to generate prejudicial results in regards to black and Hispanics. Your Lordship, again substantiating this fold of my argument, the Council would like to refer to Annexure 1 of the moot proposition. Your Lordship, Annexure 1 of the moot proposition indicates that Yugadrishti tends to perpetuate bias in its decision, which is clearly indicated as to the parameter of neighborhood has been taken into consideration for the conviction of the accused. Your Lordship, this, in judging a question of prejudice as of guilt, court must act with broad vision rather than taking such factors as incriminating factors, which is exactly what the current AI tool is doing. Your Lordship, moving on to the next fold of my argument, that is privilege against self-incrimination. Your Lordship's Article 20, Clause 3 of our Constitution states the right of self-incrimination. Your Lordships, in an AI tool such as
Right up or right against?
right against, Your Lordships. Apologies. Your Lordships, in AI tools like Compass, which is being used in USA, most of the data fed is based on a questionnaire model, which means that you pose certain questions and you collect the data from the person, so in trial. Your Lordships, such data that is being collected by the accused itself has been used as parameters of incrimination, which is against the principle of fair trial. Your Lordships, moving to the next fold of my argument, which is reasonable suspicion of bias. Your Lordship, the Indian judiciary system works on the system of beyond reasonable doubt. Thus, even if small biases or small suspicions have been created, then that particular matter has to be critically devolved upon. Your Lordships, the reasonable suspicion of bias is the standard test to determine if there is prejudice in a particular case or not. Your Lordships, in Shyam Singh versus State of Rajasthan, which has been tagged in tab 31 of the compendium, the court pointed out that the issue is not whether prejudice influenced the decision, but the fundamental question is whether any circumstance would lead a litigant to rationally believe that a prejudice has been created, which in the present case is very clear. Your Lordships, Annexure 1 of the moot proposition again has a clear indication as to how inefficient this AI tool is, and thus creating a reasonable suspicion of bias. Your Lordship, moving to the next fold of the argument is presumption of innocence. Your Lordship, this is one of the basic principles of fair trial. Any court before starting a particular case has to begin with a clean slate, which in the present case is not done. Your Lordship, the AI in present case generates a risk report at a pre-trial detention bail hearing stage itself, which tends to sway the judge against or in favor of the accused itself in the preliminary stages of the trial. Your Lordships, in AI tool, which the council will be devolving upon in the second issue. Immediately as soon as the data has been fed into the AI system, creates a certain kind of bias, and thus there is no presumption of innocence. If the bench is satisfied, the council will move to the third issue. Much obliged, Your Lordships. Your Lordships, the third issue that is being framed in this present case is whether the use of AI algorithm to predict criminal behavior violates the right to equality guaranteed under Article 14 of the Constitution of Bharat Nadu. Your Lordships, Article 14 states that the state shall not deny to any person equality before law or equal protection of laws within the territory of Bharat Nadu. Your Lordships, Article 14 mentions two tests that is to be passed for legislation to not be considered arbitrary in nature. The twin tests are, firstly, the intellectual differentia, and secondly is the rational nexus. Your Lordships, in the present case, there are various intelligible differentias. For example, gender, caste, race, etc. But what is to be devolved upon is whether there is a rational nexus to the information collected and the purpose that is sought to be achieved. Your Lordship, applying the test of rational nexus, there is no correlation between the differentia and the purpose that is sought to be achieved in predicting recidivism. Your Lordship, race is not even a relevant factor or a parameter that is to be considered while sentencing or pre-trial detention or granting a bail. Your Lordship, considering the second parameter, that is birth. Birth in a particular community does not predispose a person to criminality. Your Lordship, this has been reiterated in various cases, Your Lordship. For example, in Tehsil S. Poonawalla versus Union of India, which has been tagged in tag 35 of the compendium, it states that crime knows no religion, and neither the perpetrator nor the victim can be viewed through the lens of race, caste, class, or religion. Your Lordships, the council will substantiate this particular argument in two foods. Firstly, the data collected has no nexus with criminality, and secondly, the models so incorporated into Yuga Drishti perpetuates inequality and bias. Your Lordships, the first being religion, race, etc. are irrelevant consideration in sentencing. Your Lordship, there are flurry of judgments, judicial decisions, which strictly excludes consideration of race, sex, and even socio-economic status of the accused while convicting or sentencing an accused. Your Lordship, in the case of State of Karnataka versus Raju, which is being tagged in tag 26 of the compendium, it was held that socio-economic status, religion, race, caste, or creed of the accused or the victim are irrelevant consideration. In the present case, it can be seen that irrelevant considerations have been taken into consideration to predict recidivism, as indicated in Annexure 1 and 2 of the Mood proposition. Secondly, Your Lordships, this particular factor of consideration becoming an incriminating factor is something that is to be pondered upon. Your Lordship, the second fold, perpetuation of data bias and discriminatory feedback loop. Your Lordship, this is a technical aspect to the case. AI is much like a human being, Your Lordships. So AI tends to replicate cognitive human skills rather than automated machine learning which works on commands. Your Lordships, this data contains social, historical inequities, erroneous assumptions, and prejudices as the council had already substantiated in the arguments said before. It has been reflected that the working and the decision that the AI makes is on strong data biases. Your Lordships, Yuga Drishti in the present case incorporates the given data set using its machine learning techniques and tries to identify the pattern and correlation to the data. Your Lordship, the council will illustrate say that the people of a particular race X have more chance of recidivism and pose a higher risk to the society. Judgments and sentencing based on this evidence would lead to more people of race X imprisoned and penalized. later, the arrest records and criminal history of these individuals will be fed into AI. And hence, the data processing system generates a vicious cycle of process error. And this leads to a discriminatory feedback loop. Your Lordship, moving on to one of the fundamental principles of the judicial system of Bharat Nadu, which is to identify the causation of the crime and not to correlate the crime. Your Lordships, what the AI clearly does is mere correlation. It does not devolve into the causation of the crime as such. Your Lordships, AI operates by identifying patterns that is being fed into the AI. It just segregates data and connects the dots. And hence, this particular AI is only correlating data rather than understanding the problem, which is the fundamental principle of the Constitution of Bharat Nadu, and also that we follow a reformative justice system. There is no causation that is being addressed by this particular system. Your Lordships, now moving on to the second and the most technical aspect which the court should take note of. Your Lordships, as the Council had already mentioned, that AI is in replication of the human cognitive skills. Your Lordship, this means that the AI tool should dispassionately dispose of the cases. In the present case, there are 4 languages that is being used to predict precedents. Firstly is the random foresting method. Your Lordship, these has been mentioned in para 6 of the mode proposition, the languages used in the AI. Firstly is random foresting. Secondly, it's logistic regression. Thirdly, support vector machines. And fourthly, neural networking. Your Lordships, the Council would devolve into the technicalities of these systems. Firstly is the random foresting method. This particular method is a series of decision trees. Each tree classifies a person as a high risk or a low risk offender. And the weighted average of all decisions of each tree is taken into consideration to come into a final conclusion. Let's say there is a process where one tree's decision overweighs and there's a feedback loop where every tree starts to replicate the biased decision. Then the overall prediction leads to a biased prediction. Secondly, logistic regression. Your Lordship, logistic regression is a linear and an inflexible model. Your Lordship, in a country like Bharat Nadu, which is so diverse, which is so culturally diverse, linguistically diverse, a system of such as like logistic regression, which is trained to have linear data processing system, cannot process data of such complex nature. The third method is support vector machine. Your Lordships, there's a diagrammatic representation that accompanying Your Lordship, which defines as to how support vector machines work. Thus, this particular system classifies people as high and low risk, and there's an optimal line that separates both. If in case there is a case which is close to the optimal line, then it becomes difficult as to the AI fails in the procedure of classifying these individuals as high risk or low risk very efficiently. Your Lordships, the last model that is being used is neural networking, which is similar to human brain function. Your Lordships, the bias here is again inherent like the human brain itself. As the data is fed, there is bias that has been created already. Your Lordships, as seen in Annexure 1 of the Mood proposition, it clearly indicates the presumption that the AI has presumed has a high influence in the prediction that is being made. Your Lordship, the Council for the Petitioners have attached an article further as to how these models can further generate bias in R3 of the compendium. Hence, the Council would conclude their argument in like 30 seconds, Your Lordship. Hence, after devolving into the legal as well as the technical aspects of this AI system, it is clear that how biases, prejudice have clearly produced unjust results and is violative of the fundamental rights of the citizen. My co-counsel will substantiate on the 4th and the 5th issue.
No, you did not substantiate or submit anything about prevention or intervention before the crime takes place. CRPC of Bharat Nadu speaks about every citizen's responsibility to prevent commission of a crime if it is happening in its presence.
Indeed, Your Lordships.
Then preventive detention laws of the state of Bharat Nadu
Indeed.
require detention of persons before commission of crime. I understood your submissions to be only in relation to a criminal case which has started, trial, sentencing, but nothing I am hoping your co-contestant is going to speak about it.
Indeed, Your Lordship, can co-counsel will substantiate on the same thing. Whereas addressing your question, I would just like to say 2 points, Your Lordships. Your
I
Lordship,
think your time is over. Let the other contestant.
Indeed, Your Lordships, my co-counsel will substantiate on that.
I have a question. Will she answer or you will answer?
I think question, Your Lordships.
Because she has challenged the validity of certain procedures here.
Indeed, Your Lordships.
Now, even as the law stands now, forget about this new law.
Indeed, Your Lordships.
Is it not open to the court at the stage of considering a bail application to consider the criminal antecedents of an accused even as the law stands now?
Indeed, Your Lordships.
Number one.
Yes.
Number two, while arriving at a decision whether the accused has committed the offence or not, that is, while convicting the accused, this information is totally irrelevant, cannot be considered. In a matter of sentencing, even as the law stands under the Criminal Procedure Code, is it not open to the court to take into consideration the accused was previously convicted?
Indeed, Your Lordships.
So does not this material help the court in fixing the appropriate sentence? You can answer it or you can.
I'll answer the question, Your Lordships. Your Lordships, what the council here is trying to establish is that the court can take into consideration the previous history, the crime records of the accused. But what happens in such models, which is predicting, is they lack human instincts, experience. Thus, they tend to generate strong predictors in certain cases. And that particular strong predictors tend to get replicated in every case. Your Lordships, there are various cases which say that mitigating and aggravating factors are to be taken into consideration. Whereas the AI lacks the capability of weighing what are mitigating factors and to what level is that to be considered and what are aggravating factors in the present case. We shall not deny that the court can take parameters and the AI tool can also take parameters, but that shall not become an incriminating factor is what the council is trying to establish, Your Lordships.
So what the brother lordship is saying is that the AI data which is available, it is only recommended as such. It does not bind the court.
Indeed.
This court will eventually take its own decision. What we see in the proposition here is that the data is available, and what his lordship just said is the antecedents and the present situation of the person who is convicted, because we are speaking about sentencing. So for that purpose, any amount of data is helpful.
Indeed, Your Lordships. Your Lordships,
How the data comes to the possession of the judge for taking the final decision is.
Your Lordships, as Your Lordship itself has reiterated that the final say is of the judge, which is retaining human touch, Your Lordships. Your Lordships, this particular AI itself is developed for the purpose of cost cutting. When such decisions have been given, it is highly likely to be more influential in nature, Your Lordship, because the human would obviously presume that this is a huge data processor, and hence the cost cutting is not happening, rather the burden rather increases on the judge as to find the reasoning and the tracing of this particular AI. This AI algorithm is not even transparent, Your Lordship, and hence it becomes difficult and the burden again lies on the judge to trace where the error had occurred.
Does any provision of this Act say that material collected by AI can be as it is used by a judge while deciding a case?
Your Lordship,
Is there any corresponding amendment to the Criminal Procedure Code saying that without that material being brought on record through the medium of evidence, in a manner known to the Evidence Act or CRPC, can the court make use of it as it is?
Your Lordship, the council please ignore this.
But
My co-counsel will further proceed with the issue.
permission to address the bench collectively as Your Lordships. Your Lordships, may the co-counsel answer the question posed to my learned friend? Your Lordships, am I right in presuming that Your Lordship had questioned whether a subsequent amendment had been made to the CRPC to facilitate the implementation of the AI? Your Lordship, the moot proposition is silent on whether an amendment has been made, and hence the Council shall proceed with wider ambit of constitutional safeguards, Your Lordships. Your Lordships, firstly, regarding the question posed as to whether the AI can be used in bail and pre-trial detention. Your Lordships, in the case of bail and pre-trial detention, no exhaustive judgment is made. However, bail hearings consider three factors: the risk of an accused absconding, secondly, whether he is a threat to the victim and the witnesses, and thirdly, whether the judicial process shall be influenced by the accused when he is at large. And hence, Your Lordships, the other factors considered, including social media, digital communications, which are of a very sensitive nature, shall not be considered at all at such phases of your hearing, Your Lordships. Can the Council proceed with the
Will
issues?
you answer his question also? Preventive.
Can, regarding preventive detention, Your Lordships?
Yeah, that is the pre-case data.
Indeed, Your
So
Lordships.
what your friend submitted was only in relation to, the arguments were only directed in relation to a case being conducted. For example, the evidence, the cross-examination, the sentencing. But what if the data is available to prevent a crime?
Indeed, Your
Probably
Lordships.
the Bombay blasts would have been prevented. I'm sure you're not born
Indeed.
around that time. But then there are series of bomb blasts in some parts of the country. Then in some parts of Tamil Nadu there were bombings. And so things like this, if these serious incidents could be prevented.
Your Lordship, the Council will advert to this in two folds, Your Lordships. Firstly, Your Lordships, there are two existing databases which take into account such information, which is the NAT grid, which is the National Information Grid, and CNMS, which is Central Networking of Information. These are used by investigative agencies to detect and prevent such threats, Your Lordship. However, the Council feels that considering the independence of the judiciary, such information shall not influence the fair reasoning and magnanimous judgment of the judiciary. As for preventive detention, Your Lordships, the Council has adverted that in the issue relating to privacy, the Council has adverted that collecting information from people under preventive detention is an overreach of the right to privacy. The Council has devolved upon this by citing cases which state that the people under preventive detention are not penalized. These people are normally prevented. They are not penalized. They are not accused in the true sense. In such a case, gathering their information in itself is a judicial overreach, Your Lordships. And hence, the AI shall not be used in preventive
Go ahead.
detention.
If you're not satisfied with your argument, we are going to have a judicial overreach only.
Apologies, Your Lordship, the
No
Council
issue.
had phrased it wrongly. It is an overreach, not a judicial overreach in any sense, Your Lordships. Shall the Council begin with the arguments, Your Lordships?
Good.
Indeed, Your Lordships. The fourth issue pertains to the use of AI algorithm raises concerns about transparency, accountability, and due process as guaranteed by the Constitution. Your Lordship, transparency means the right to know, which is a corollary of Article 19(1)(a), the freedom of speech and expression. Your Lordship, transparency is the right of access to interpretable facts. Your Lordship, the right of transparency is not even at issue here. This would be adverting to the submissions of the respondents, Your Lordships. Your Lordships, paragraph 30 of the submissions by the respondents, Your Lordships. 30 and 31, Your Lordships. Are Your Lordships with me on this? Can the Council read out the excerpt? Paragraph 30 states that the non-disclosure of information compromises transparency thereby impinging upon the citizens' right to know. This contravention jeopardizes the delicate equilibrium between national security imperatives and the constitutional entitlement to a transparent and accountable criminal justice system, which is against the stand taken by the respondents, your lordships. Paragraph 30 also mentions that the absence of detailed statistical proofs and restricted public accessibility to the performance data exacerbates, increases the opacity enveloping the algorithm's operational framework. Your lordships, and hence the respondents themselves have acceded that Yugadishti poses a great problem to transparency. The same has been replicated in the case of accountability and due process as well. However, for arguendo, the council will argue the issue, your lordships. Firstly, the council will contend that Yugadrishti is a black box AI. There are two types of AI, your lordships. White box, which allow transparent access to the algorithm, and black box, which prevents any access to the algorithms. Yugadrishti in the present case is a black box algorithm. Secondly, the council will elucidate upon the consequences of loss of such transparency. Your lordships, the council would like to take the case of Vishaka versus State of Rajasthan. Tracing the judicial process of this case, the Jaipur Sessions Court had initially acquitted all the accused in this case by citing religious factors as incriminating and exculpatory factors, your lordships. This was highly a biased judgment and a human fallacy. However, this human fallacy was very evident in the ratio decidendi of the case and was subject to the scrutiny of the Supreme Court, which resolved the issue subsequently. However, any bias in the AI can never be detected, your lordships, and never be remedied. Your lordships, for this purpose, the council will also advert to diagram D1 tagged in a compendium, your lordships. Diagram D1 tagged in the compendium is a parabolic diagram, your lordships. In the parabolic curve, there is a straight line. This straight line emphasizes on the optimal functioning of the AI. Any slight deviation from the straight line would lead to bias, which is a presumption on the part of the AI. Any deviation on the other side would result in variance, which is a difference between the test data and the source data which is actually fed in the AI. Hence, your lordships, the bias can never be detected in the black box AI. Proceeding with the issue of accountability, your lordship, the council will quote the case of DDA vs. Skipper Constructions, Nilavati Behera vs. State of Orissa, and SP Gupta vs. President of India, tagged in tag 2, 23 and 33 of the compendium. All these cases emphasize that openness and accountability are two sides of the same coin. Only when there is transparency in the government can the government be laid accountable. Further, it establishes that even in the absence of a fiduciary relationship between the government and the citizen, the government can be held accountable for any crime. Your lordships, in such a case, fastening accountability on Yugadrishti becomes a problem since its processes in itself is not open to scrutiny, your lordships, in the interest of national interest. However, national interest is nowhere proved in the particular case, and there are instances like the use of compass in the US, your lordships, where the algorithm is selectively subject to the scrutiny of a few people. Such access may be allowed. National security can be balanced with transparency. However, the respondents have taken no such steps, your lordships. Moving on to the term due process. Due process was specifically omitted from the Constitution. However, its Indian variant, the procedure established by law, is inherent in Article 21, your lordships, and it means, according to the Maneka Gandhi case, a just, fair, and reasonable procedure, your lordships. The use of the AI in the judicial proceedings defeats this very purpose. This is because of, first, oversimplification of complex issues. Your lordship, adverting to paragraph 6 of the Moot proposition, it is observed that natural language processes are evolved to translate the language of the people into language of the AI, which is mathematical language. Your lordship, data can never represent a human being. Human beings are complex organisms. Secondly, lack of individuality. Thirdly, dehumanized justice. Fourthly, loss of autonomy. This implies two facets. Loss of autonomy of an individual due to excessive surveillance by the state as reinstated in the case of Manohar Lal versus Union of India, which is the case of the Pegasus spyware, Your Lordship. And secondly, loss of judicial autonomy. Your Lordships, this becomes a case where the judiciary is forced to become reliant on the executive providing information and ceasing to exist as an independent authority, Your Lordships. This should never be allowed in light of separation of powers, and the AI should be struck down on this basis in itself, Your Lordships. And finally, it is against the reformative justice system as elucidated by my co-counsel. If the bench is satisfied with my arguments, the council will move on to the final issue.
Reform versus revolution. This will probably bring in revolution to the entire system.
Indeed, Your Lordship. Your Lordships, Article 51AH imposes a fundamental duty on all citizens to foster scientific temper, which includes bringing in revolutions of such sorts. However, that being a directive principle is still subject to the fundamental rights. Anything that infringes upon the fundamental rights can never be allowed, Your Lordships.
Fundamental rights, Article 21,
And
you have the right of cross-examination. If the data is presented, you have the right to rebut it.
indeed, Your Lordships.
You, in the sense, not the public-spirited petitioners here, but in any given case, the accused.
Indeed, Your Lordship. However, such data is not available in an interpretable manner. Consider a country like Bharat Nadu, Your Lordship, where illiteracy is prevalent and technical illiteracy is even more prevalent. In such a case, Your Lordship, it is not available to any person to scrutinize the outcome of the AI and rebut it, Your Lordships.
Good for the lawyers, more work.
But bad for the citizens, Your Lordship, which is why the public-spirited NGO will
The
oppose.
citizens represented by lawyers. So, the citizen, the accused in a given case will have the right of representation, right?
Indeed, Your Lordships. However, considering the practical scenario where all the lawyers have to be re-educated, unlearn, relearn the technical aspects of an AI, the lawyer will have to take on an entire education system, Your Lordship. And even in such a case, educating oneself about the AI is not a constant process. AI is dynamic. It is a reflection of human cognition, and it can never be assessed as such, Your Lordship. It is a Indeed, Your Lordship, the council is not contesting as to the ability of the lawyers to learn or the teachers to teach, but just that the AI is unpredictable. It can go rogue at any time, Your Lordship, as indicated by diagram D2, the parabolic diagram, Your Lordships.
Madam Counsel.
My question still remains. So long as the basic evidence act of the criminal procedure code is not amended by this legislation, the validity of which you are questioning, there is no non-obstante clause to my knowledge, because you are not told. Notwithstanding anything contained in CRPC or Evidence Act, whatever is collected through this AI would bind the court, and without a trial, the court has to proceed on that basis. Is there any provision?
Your Lordship, that is.
Is it not open still with all that material for the accused, as they put it, to cross-examine the prosecution witnesses? Can the just court convict the accused or do everything only based on the material collected through this algorithm, or is it bound by the material placed on record after giving an opportunity to cross-examine the prosecution witnesses?
Your Lordship, it is still open to cross-examine the witnesses. The judicial process and trial proceedings proceed as such. However, the council will argue in two folds. Firstly, if the judicial process is already efficient in cross-examining the witnesses, there is no use of a black box here.
I didn't catch you. Please repeat.
Your Lordship, the judicial process remains intact in this case, Your Lordships. Even in such a case, firstly, the AI introduces an element of bias in the already efficient judiciary and the human touch of the judges, Your Lordship. Secondly, the data collected is non-representative, non-exhaustive, and places a burden on the judiciary to re-examine erroneous data and trace untraceable biases, Your Lordships. And the primary purpose of introducing this AI was cost cutting. However, it shall only increase the cost on the state exchequer and the burden on the judiciary.
I had one question. You said data is creating human beings here.
Your Lordships.
Data is creating human beings. My contention is that it is the human beings who have created the data, and the same data is fed into the system. So in such a scenario, data is realistic. So what's wrong in relying upon that data?
Your Lordship, the Council will argue this also in two folds. Firstly, adverting to report R4, the data collected is not representative because NCRB tends to collect data directly from police records, arrest records, including history sheets, Your Lordship. The Council has made a submission in the fourth issue arguing that such data sources are unrealistic, highly unreliable and volatile, Your Lordship.
Nevertheless, they are indicative of the nature of the criminal.
Your Lordship, the Council will quote the case of Sirajuddin versus Superintendent of Police, where it was held that there is a general pattern adopted trend by the police to continue to retain the names of person in the history sheet, showing them as rowdies without any justifiable reasons. Your Lordships, hence the data collected might not even be reflective of the criminal antecedents of a person, and even people, innocent citizens, may be subject to such bias, Your Lordships.
But the objective, as you said, is to make this illiterate people of the nation to follow scientific, develop their scientific temper. So don't you agree that this AI tool or the law is now eliminating human bias and making a scientific temper, giving more science to decision making?
Your Lordship, the Council will refer to the submissions of the Co-Council stating that yes, the AI tries to remove human bias. However, it clothes the human bias in technological bias, which is undetectable, Your Lordships. Human bias and human policies are detectable, subject to scrutiny. However, in an AI, it is undetectable, untraceable, and manually unalterable.
Continue.
Indeed, Your Lordship. The Council will make a very brief submission regarding the fifth issue, considering the depravity of crime, Your Lordships. Firstly, Article 21 states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Your Lordship, the right to privacy is highly infringed in this case due to the collection of very private and sensitive data, Your Lordships, as elucidated in paragraph 12 of the moot proposition. Your Lordships, adverting to the case of K.S. Puthasamy versus Union of India, the Council will now try to fulfill the test of proportionality. Firstly, the action is sanctioned by law, which it indeed has been. Secondly, the proposed action must be necessary for a legitimate aim. It probably is in light of crime prevention. However, the third parameter, the extent of such interference must be proportionate to the need of such interference. Your Lordships, as adverted by the Honorable then Chief Justice in the case of K.S. Puthasamy, he has observed that if I had a nut and a nutshell, I would rather use a nutshell to crack the nut rather than a jackhammer. The respondents in this case have adverted to use a jackhammer to crack the nutshell, the crime prevention. Your Lordship, the Council will classify the data under three heads. Firstly, data regarding the online personality of a person, which includes social media, communication, and online activity. Secondly, data regarding bad character of the accused, which includes previous conviction, substance abuse history, and behavioral and psychological assessment. And thirdly, data like history sheets and case diaries. And finally, data regarding socio-economic structures. Your Lordship, the Council would advert to state that, firstly, regarding social media, in PUCL versus Union of India, tagged and tag 50 of the compendium, Unique Identification Authority of India versus CBI, it has clearly been stated that the Unique Identification Authority of India shall not transfer any personal data of any person to any other agency without the request of the person or the consent of the person, even in case of national security. Such is the importance of right to privacy as provided by this Honorable Court, Your Lordships. When the bad character of the accused is considered, Your Lordships, in the case of Gayala versus Emperor, tagged in tag 14 of the compendium, it has been held that looking into the police record and being influenced by the observation regarding character thereof is against criminal jurisprudence. This has been backed by several judgments, Your Lordships. For instance, Ram Lakhan Singh versus State of UP, Tirumurugan versus SP, etc. Finally, Your Lordships, the Council has already proved that history sheets are unreliable. Considering the depravity of time, the Council will substantiate that the lack of monitoring mechanism is reflected in the submissions made by the petitioner, Your Lordships. If the Lordships are satisfied with the arguments, the Council will advert to the prayer. Indeed, Your Lordships. In light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed before this Honorable Supreme Court that the petition be maintainable and the law be struck down as unconstitutional, and for any other order in the light of equity, good conscience, the Council shall forever duty-bound pray. It was an honor argued before this Honorable Supreme Court. The Council seeks permission to retire.
They are not sought for striking down the law. They have only said certain provisions seek to disclose what those provisions are. You are challenging the constitutional validity of the procedure stated.
Indeed, Your Lordships.
You are not challenging the constitutional validity of the entire law.
Your Lord,
Controversies, yeah.
may the Council answer this question before retiring, Your Lordships? Your Lordships, the moot proposition is silent on the specific provisions
I
and
knew that
hence,
would be the answer. I knew that would be the answer, but still I took a chance.
the Council will challenge the essence of the Act, Your Lordships.
Because the judges are also handicapped in every moot court class of
Indeed.
and the organizers justified saying that we have deliberately kept it.
Council seeks permission to retire.
Warm greetings to your lordships. The council acknowledges the gracious presence of the bench. However, for the sake of...
Have to complete your course and become a lawyer or critics to the judges. Moot court, everything is deviated. Right.
Noted, your lordships. However, for the sake of brevity of proceedings, would like to seek the kind consent to collectively address the bench as your lordships. Obliged. Your lordships, I will be taking up issue 2 and 4, whereas my co-counsel will be dealing with issue 1 and 3, and we will be speaking for 21 minutes each, reserving 3 minutes for sir rebuttals. The council represents the respondent, the Union of Bharat Nadu, in the matter of the Democratic Reform Projects and others versus the Union of Bharat Nadu. The council seeks permission to proceed with the arguments. The present case deals with the constitutional validity of the use of Yug Drishti in predicting criminal behavior. For the sake of the same, I will be making 2 broad submissions. Firstly, the use of an AI algorithm in predicting criminal behavior does not violate the right to equality as enshrined under Article 14 of the Constitution of Bharat Nadu, but disproportionately affecting certain communities. Secondly, the use of Yug Drishti does not violate the right to privacy as guaranteed under Article 21 of the Constitution. Before I begin with my submissions, I would like to draw your lordship's attention to the case of Maneka Gandhi versus Union of India to establish the constitutional spirit. It was held in this case that Article 14, 19 and 21 shall be harmoniously constructed. At the bottom of all of these 3 articles lies the test of proportionality, rational nexus and arbitrariness in theory and in essence the quality of life. I would also like to highlight the case of Kharak Singh versus State of Uttar Pradesh, which observed that Article 21 does not merely mean animal existence, but it also includes all limbs and faculties by which life is enjoyed. The council acknowledges the fact that the rulings, the ratio decidendi of the in this case was overruled in the case of K.S. Puttaswamy. However, the council merely relies on the statement for reference. Moving on, firstly, with regard to the question of equality, the council relies on the landmark judgment of State of West Bengal versus Anwar Ali Sarkar, as cited on footnote 8 in the memorial and page 42 of the compendium. In intelligible differentia as laid down in this case was misinterpreted by the counsel for petitioner. I would like to highlight here, on a bare perusal of the facts of the case, it becomes clear that the data is only collected from the individuals who were priorly engaged in some criminal behavior. This
Do you have examples of any other state, country having the similar laws? Is there any intelligible differentia? Is there any intelligible data about use of these kind of laws elsewhere?
I beg your pardon, Your Lordship.
State of Bharat Nadu, you are representing state of Bharat Nadu.
Yes, Your Lordships.
You are defending the enactment of these laws in relation to the use of artificial intelligence.
Yes, Your Lordships.
Is there any other state or country apart from state of Bharat Nadu using these kind of laws?
Indeed, Your
Do you
Lordships.
have any data in relation to for use against these kind of
Indeed, Your Lordships. I would like to draw an analogy for face recognition technology used by recently developed by a Chennai startup in India, that is face tagging. Now, a recent news article would show that this tool was developed across 450 booths in Bihar, and it also helped curb bogus voting. In addition to that, I would also like to refer the case of Loomis versus Wisconsin in the Supreme Court of Wisconsin, where it was held that the use of AI tool Compass that was employed by USA, it was held to be constitutional. If it satisfied Your Lordship's inquiry, I would like to
That's
move.
the only case available. Is that the only case available, or there are other laws enacted by other countries, states in relation to use of this?
Your Lordships, I would deal with that while I deal with the fourth issue, that is the right to privacy. If Your Lordships have no preliminary inquiries, On a bare perusal of the facts of the case, it becomes clear that the data is only collected from the individuals who were priorly involved in some criminal activity. Now, these individuals form a distinct, reasonable class of their own and are separate from those who were not previously arrested, convicted, or detained under any preventive detention. Referring to para 12 of the fact sheet and refuting the arguments put forth by the counsel for petitioner, the counsel for respondent pleads that the data collected, also referring to para 12 of the fact sheet, the data collected is exhaustive in nature. The AI considers a myriad, the AI takes into consideration a myriad of factors before it delivers its decision. The determination of this separate class is done effectively by collecting diverse data from individuals, which provide insights into their overall lives, life circumstances, making it reliable. If it may please the court, I would like to draw the court's attention to page 62, paragraph 17 of the compendium, to the recent judgment of State of Uttarakhand versus Sudhir Budkoti and others, where the court observed that an interference would only be called for on the court being convinced that the classification causes inequality in the group form, firstly, and secondly, when a classification is made on the recommendation made by a body of experts, constitution for the said purpose, courts will have to be a little more wary of entering into the said arena. Further, as evident in the moot problem, there exists no inequality of the new class that is being created, and secondly, a body of experts coming from a range of specialized backgrounds was created for development of youth regime. Hence, it is pleaded that the classification was reasonable and just. Having proved that the reasonable classification was made by the union, the council further moves on the second part of the first submission, that is, the action of the state is not arbitrary, and there exists a rational nexus between the action of the state and the object sought. For the sake of the same, the council relies on the judgment of Menka Gandhi versus Union of India, which clarified that arbitrary state action is when unbridled power is used by the state and there exists no restraint to that power that is being used. A bare perusal of the fact sheet, specifically paragraph 18, shows that the law maintains that the judiciary has a final say in cases where the judge's decision varies with that of youth regime. Hence, there exists a further review mechanism to correct any biases, any potential biases or errors in the decision of Yog Drishti. Further, paragraph 16 of the fact sheet, the object that is being sought by the union is materialized in terms of cutting down of administrative costs and effective judicial decisions by the court. Finally, I wish to point page 76, paragraph 8 of the compendium, where Justice Bhagwati, speaking for the 5-judge bench in R.K. Garg versus the Union of India, held that every legislation, particularly in economic matters, is essentially empiric and based on experimentation. There may be crudities, iniquities, and even possibilities of abuse, but on that account only, it cannot be struck down as invalid. In total, the Council submits that Yug Drishti, in contrast to violating the right to equality, actually promotes it. The Council also makes a reference to Article 38 Clause A and 39A respectively, which provide equal justice to all and welfare of people by securing a social order.
The cost argument, the increased cost argument of the petitioner, we are not convinced with it. We know that eventually cost will be cut in relation to judicial time. But what about the bias, technical bias, as your friend was arguing, that there is a possibility of collating technical data which even the human beings can't find out, that there could be a mistake in the data. If that is true, if what your friend is saying is true, then we are in for some kind of a disaster. Is it not?
Your Lordships, I don't understand. What kind of mistake is being referred to here?
No, your friend has referred, in the petition also it is there, that there is possibility, there are two things your friend argued. One is the possibility of human bias based on the AI data. The other is the possibility of the data itself being inaccurate.
For the sake of the same, I would also like to refer to section 437 of the CRPC, which provides for the conditions of bail. So, that the counsel for the petitioner has also argued. The myriad of factors that are being considered here is for the sake of the same, so that there exists no scope for mistake or any error.
What your friend argued is, we won't even know that the data is inaccurate. That's the argument of the petitioner. Even we are not aware of such a situation. But the argument of the petitioner, of course, is not based on any scientific data here, because nobody can predict or find out if there is inaccuracy in the data.
And hence, I would say it's merely a hypothetication.
Okay, good.
Well, how we are linking Article 38 and 39A in this context, I'm not able to get it.
Linking of Article 38 and 39.
Yeah, you have said something.
Indeed, Your Lordships. Your Lordships, 38A state to secure a social order for the promotion of welfare of the people. Firstly, the Council argues that the introduction of Yug Drishti it does not violate the right to equality, but essentially promotes it, hence promoting welfare. Firstly. Secondly, Article 39A, which talks about equal justice and free legal aid, the argument is based on I present the same argument that it promotes equality, hence providing equal justice to all the citizens.
How is this not related? That's what our judge is asking. How is this related to promoting equal justice? Under 39, link your law that you have enacted to securing these two principles, Article 38 and 39. The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, political shall inform all institutions of the national life.
How are these articles relevant to the issues that we are discussing?
Indeed, Your Lordships. There, the data that is being collected is stored, and machine learning processes are being used to process this data. Now it becomes that it is submitted that there are clear-cut compartments where this data is being stored, and hence there cannot be any potential scope for error in misplacing the data.
How this would lead to social, economic, political justice? Collection of data is scientific, that's a presumption. Fine, good. But how will this lead to furthering of the objectives under Article 38?
Your Lordships, I will get back to you in surgery, please.
Carry on.
If your Lordships have no preliminary inquiries, I would like to move forth with the fourth issue. While addressing the fourth issue, I have divided the argument into two links. Firstly, the state's action is in line with the proportionality test, and second, the state's action is in conformity with the principle of consent. The test of proportionality, as laid down in the Puttaswamy judgment and expanded in Vineet Kumar versus CBI of Mumbai, also produced at page 94 of the compendium, requires that for the government to be able to lawfully interfere into a person's right to privacy, it will have to go through the following criteria. First, the action must be sanctioned by law. Secondly, the proposed action must be necessary in a democratic society for legitimate aim. Thirdly, the extent of such interference must be proportionate to the need of such interference. And fourth, there must be procedural guarantees against abuse of such interference.
To go to the fore, learned brother asked the question, the first of your points about the source of power to enact such a law is important. You refer to Article 38 and 39. When you come back with your sir rebuttal, you better be prepared for that. Because after you cross the first, the source of power to enact such a law, then the next three will continue. The next three will fall in place. The first one itself, the source of power.
The act must be sanctioned by law.
You must have the power to enact the law. You have the power to enact the law is the question. What, sir?
Indeed, your Lordships, there was a law that was being enacted.
No, you don't hurry up. You said you will come back in the sir rebuttal to answer that. You go to the 2, 3 and 4.
Yes, Your Lordships. In the instant case, the government of Bharat Nadu has passed a separate law to allow the collection of data from any individual who has a prior criminal history. In furtherance of the foregoing, the Council would like to draw your Lordship's attention to paragraph 12 of the fact sheet. The Union has brought in legislation to mandate the collection of data from individuals with prior criminal history. Further, the Council seeks to highlight the need for such legislation while referring to paragraph 2 and 3 of the fact sheet, which clearly articulate that Youth Drishti was introduced in view of rising crime rates and unavailability of appropriate resources, hence making the action of the state proportionate with the object that is being sought. Finally, the fact that human judge's decision is considered final and binding proves that the role of AI is merely suggestive in nature and can be overruled if found to be erroneous. In light of the above, the Council submits that there exists a review mechanism and the decision of Youth Drishti is not final. For the next link, the Council relies on the well-established principle of implicit and explicit consent as enshrined in international documents like OECD and GDPR. Article 5.1 of the GDPR lays consent from the data principle as being part for the criteria for lawful intervention by the Union. And the Council puts forth that the same when expanded in the case of R. Rajgopal versus State of Tamil Nadu, promulgated that test of consent while publishing individuals' data is different if the individual himself thrusts themselves into a situation of controversy. Further, the Council brings to attention the distinction between a surveillance state and the concept of authentication. In the case at hand, the state only aims to collect information from high-risk individuals with a high probability of committing a crime, rendering void the primal importance given to the principle of consent of an individual while collecting data. To conclude, it is submitted that the arguments for the counsel for petitioner lack any legal merit, and the use of Youth Drishti does not violate the fundamental rights of individuals, rather upholds the constitutional values. It was an oral argument.
warm greetings to the bench. I am counsel for the respondent dealing with the issue first and issue third. First issue is, does the use of an AI algorithm in bail trial, pre-trial detentions and sentencing violate the right to fair trial guaranteed under Article 21 of the Constitution of Bharat Nadu? If bench don't have any pre-queries related to issue, counsel seeks permission to proceed with the issue. This is humbly submitted before Honorable Court that in the present case of use of an AI algorithm, criminal justice system is not unconstitutional as a AI such as Yuga Drushti, when employed in a pre-trial detention, bail hearings and sentencing within the criminal justice system of Bharat Nadu, does not raise grave concerns regarding its compatibility with the right to fair trial as guaranteed under Article 21 of the Constitution of Bharat Nadu. For arguing the same, I will divide my issue in the three main headers. First will be, it preserves judicial discretion. Second will be, it works on a data-driven decision-making process. And thirdly, it's in its nature promotes an idea of speedy trial in itself. When starting with a preservation of a judicial discretion, it is imperative to acknowledge that AI algorithm function as a tools to intend to argument decision-making process rather than replace judicial discretion. Judges in this context maintain unequivocal or dismiss the recommendation put forth by these algorithms. The integration of AI serves to complement the judicial decision-making process by furnishing comprehensive insights, thereby facilitating a more well-informed and expeditious assignments of a case. The amalgamation of AI with human judgment contribute to the legal system that is not only more efficient but also retains a critical human touch, ensuring fairness and equality. After arguing this passage, I would like to draw a court's attention to the page number 5 of the compendium with the passage number 36 of the case of Zahira Abibullah versus State of Gujarat, where the Supreme Court has given some conditions of a fair trial. First condition, an unbiased judge. Second, judicially calm atmosphere. And third, of a presumption of innocence. When we see an unbiased judge, it means judge should not be biased. But when the bias was argued from the side of petitioner, it can clearly be seen that they are talking about the bias suggested from the side of AI. But in a Chandrappa versus State of Karnataka, it's clearly mentioned that if in the case of presumption of innocence, where there will be a chance of creating a guilt from the same evidence and presumption of innocence from the same evidence, it's liability of a judge to proceed with the presumption of innocence, not the liability of the third party which is working in the favor of the justice in this case. So the argument put forth by the biasness of AI is not mandatory on judges. Judges secures their own judicial discretion, which is important in the crimes consideration like bail hearing. As we mentioned, the CRPC's article, CRPC section 437, there we consider all the factors like questioning the reason which are considered and the data. There are some things can fly through the country or not, a person can damage evidence or not, a person can threaten a other party or not, and these things can be connected to its socio-economical background, its other background. It can be argued before the court, and this is permitted to argue before the court, and that's why the data taken is not unreasonable. The data taken can be adjudicated by the judge on his own discretion, and that's why here we fulfill the one condition of a judge given in the Zahira Abibullah versus State of Gujarat, and second-handly, we also fulfills the condition of presumption of innocence. Now talking about the judicially calm atmosphere.
Guidance. Don't say liability. Say duty of intent, then duty of intent. Don't use that expression liability.
Counsel plead
Not very
ignorance.
appropriate expression.
Counsel plead ignorance for having the knowledge for the proceedings. And well, we are going forward with the judicially calm atmosphere. It is argued that the presumption of innocence can be harmed. But we know the AI algorithm called amicus curiae, where judges and court can appoint a third party in the interest of a court which can bring some evidence. Here the law is mandated, and law is just appointing a third party in the interest of a justice, not in the interest of a personal capacity to provide certain facts, provide certain data which can be helpful for giving decision in the help of a justice merely. So here the argument put forth that it is not with the compliance with the adversible system can be refuted that it is in a compliance with some laws. It is coming as something as a third party which is providing evidences, data just for a justice, not.
Mr. Counsel, you said that the data that is generated through AI is only helping the judge in arriving at a particular decision. Now the petitioner's apprehension is that this data that is generated may indicate race, religion, caste, etc., of the criminal. And therefore, how does your law provide a mechanism that despite a strong indicator of these things, religion, race, caste, your law is insulated from bias? Is there any guidelines? Like in cricket, we have a third umpire, and then the third umpire, this is what shows, and the judge on the field makes a decision. Is something built in there in your law to say that this is still, if there's strong bias, that this person belongs to this community religion, therefore there are probable chances of he committing the crime or having committed the crime? Yeah.
I would like to answer question in the two parts. First parts, I would like to refute the argument of a caste and religion because it is not mentioned in a in the fact sheet that caste and religion are taken into consideration. So that is not the thing. The race is considered in the whole procedure. Here we can see that we have some laws like where some communities were decided as to be criminal communities. Here we have some statistic information also that some communities are more often to be found in a prisons also. But here the race, we are not arguing that the race is a good thing to consideration, and that's why
it is precisely
and that's why there is a
is not the court going to be prejudiced by mentioning the race and other details. That is his question.
And for your information, if you look at the British colonial history, they had a specific law criminalizing certain tribes. That was done. There's a law passed which said certain tribes are criminal tribes act.
Yes, and that's why I want to draw attention of a judges to the para 17. Here we are talking Bharat Nadu has taken steps to minimize the potential for bias and error in AI algorithm, including providing regular updates and improvements based on a feedback from a legal expert and a data scientist. Also, there is a scope of amendments in this AI because it is in a review stage. If we are not satisfied with the decision of a judge, we can appeal against it. Here also, if we are not satisfied with the assumptions put forth by this AI, we have still opportunity to review it and feedback it and act is it in a review condition. As representing the government is trying to safeguard everything that could be in accordance, that should be that is in accordance of
So
justice.
if we say that part of the legislation where it provides for selecting data regarding race, religion, if that part is removed, you're happy?
If that part is removed and still
Only to that extent. Only to that extent, these provisions are unconstitutional, cannot be. Would that suit your thought?
I request just part of the question.
The question is, he has raised a question. Some information regarding the race, religion and everything is likely to prejudice the judges. Supposing we come to a conclusion that it is indeed likely to prejudice a fair trial and give a fair decision, will it be okay for you if we say that at least that part of your enactment which provides for collecting that information regarding the race, religion and caste is unconstitutional? At least if that could be separated.
As I answered, caste and religion are not mentioned in the data. They are not taken through the data. And for the
Supposing the Act says so. If the Act provides for taking those things also, collecting data about that also. If we say that part of the enactment is bad constitutionally, will it be okay for you? Will you accept this?
as this case and this aim is put forward by the government to provide justice through the AI, as an incapacity of representing the respondents, I don't have answer right now, but I will make sure I will consult with them and answer it with
But at least we will abide by our decision because we are bound by it under Article 1.
We will abide by your decision, and we'll make sure. And I know you will make sure it will be in accordance with the justice. While judge while questioning the petitioner also, mitigating the human bias can be one of the factors. It is also mentioned in the Navjot Singh Johar versus Union of India, where D.Y. Chandrachud said that where we are coming with the society of cultures, where we are coming with the society, where are lots of things, lots of peoples and variety we have, there are chances of considering the past data, historical data or cultural data may influence a human bias against that case. So that human bias can be reduced in this consideration, where we are giving an equal platform for everybody, an equal mechanism for everybody, equal data is taken and the equal phenomena is constitutes for giving the probability. And again I am repeating, AI is just making sure that it is giving probability of someone to committing a crime. AI is not interfering directly in the decision and not directing anything to that. It's the only decision of a judge. If we take an example, just
if it has no legal statutory basis or system or value attached to it, why do you need it? The investigating officer in any criminal offense, he can add this additional data into the charge sheet. Why do you need any statutory force for the data?
100%.
As the state of Bharatnagar is a diverse and populous nation with a complex legal system, seeks balance to right and interest of citizens. As Bharatnagar continues to develop technology, they are facing some problems like increasing criminal rates. They are going through the problems like pending criminal cases and state of crisis in a criminal justice system, as mentioned in the paragraphs. They are coming with the idea to provide speedy justice also. They are coming with the idea of provide fair trial also, and they are coming with the idea to use that technology with the limited sources they have to come with providing justice to the people. Now when I am directing myself to your question, which is related to law mandating, if I sounded like that the law is not mandated for same, I am apologized for the same. I just mentioned that it is giving the probability and it is put forth in the assumption before the court to take into consideration.
Law is needed at all, is what he is saying.
Yes, law is needed because the state crisis, of the criminal justice system, the pending cases and going through the high rate of criminal increase, the law is necessary to solve this question and make this criminal justice system
Some
more strong.
amendment to CRPC is evidence that we did not have sufficient separate legislation.
As AI deals with some plural concepts is in own nature. So AI requires its own law to regulate AI and regulate things related to AI. That's why we are not doing the amendments. We are mandating a whole new law which can consider for the AI for that matter. If the bench don't have any pre-queries related to next issue, which is the third issue, council would like to start with the issue number 3. Here, the issue revolves around does the use of an AI algorithm in criminal justice system raises concerns about transparency, accountability, and for that matter, due process of a law. If we see the transparency, the AI integration of AI algorithms criminal justice system serves as a bulwark of a transparency of fostering objective decision making. While unlike human counterparts susceptible to unconscious biases, AI algorithms operate on a foundation of data driven process, as I earlier argued. This instrumental shift minimizes the influence of a subjective judgment to the certain historical data which can come with the human biases and establishing a paradigm where decisions are grounded in the concerted evidence rather than a human prejudice. This commitment to evidence-based outcome enhances transparency, ensuring that the pre-trial decisions are guided by impartial and discriminable rationale. This is argument put forth from the side of respondent. Now, refuting the argument put forth by the petitioner related to the training data and source code, why it is not publicly available and it can harm a transparency. If we see that AI algorithm works on a data division process, we will provide some data to it. If we will make sure, if we will open to it the public that this thing should be get priority in the decision making, that's the if you're contending A, if you're fulfilling B, and if you're fulfilling C. It can make open to the public that you will be just liable for the crime if you will fulfill the condition A, B and C, and there are high chances are not available and which will come with the review and feedbacks in the future, but for now they can pose a question to the national security. Again, the data context of a socio-economical backgrounds also, where we can see that cyber crimes majorly focus the soft targets like old age peoples, like the peoples who are going to the economical crisis, and if we will open this data to the public, there are high chances of these tribal criminals to use these soft targets, and the aim of reducing criminal rates will be counterproductive because of opening this data against the government and increase in a crime rates also. And also there are concepts like preserving the reputation of accused till the decision given by the court that accused is liable for the punishment or not. So there can be social stigmas related to the personal data taken from that person, and if that data comes out, that reputation of that person also can be get harmed, and that's why we are making sure with the reasonable restrictions and data driven process that transparency should be considered, but with reasonable restrictions in favor of a justice and welfare of a country. As mentioned in the state of Punjab versus Baldev Singh, national security restrictions can coexist with the transparency, and in this case these principles are coexisting with a transparency. Now the question of accountability, the paramount aspect of accountability in the integration of AI algorithms into criminal justice decision making lies in the preservation of human oversight. These algorithms function as supportive tools rather than autonomous decision makers. Discretion retains its primary. I would like to deal this issue in the some sequence. Like first sequence, we developed this from the legal scholars, from the scholars who knows how AI works, and for the engineers who knows the technicality and also legality of it. So there are reasonable persons behind creating AI as Yuga Drishti for that mandate. Then we are also preserving the judicial discretion. That should be a final say, and the justice should be retained in this condition by the judicial review. And again, then we are giving the chances to give a feedback and also review against the AI, and also we have an appeal against if there is a human bias from the side of a judge. So we are not harming accountability of any cost and not harming ideas of a fair trial of any cost also. And now going to the due process, I would like to summarize all arguments put forth by our side. Because what is due process? It's following a procedure of law with testing the fairness of that law. And if our law is not harming the fairness of a trial, if our law is coming with the theory of reasonable classification with having the nexus and objective to provide a natural, provide justice to the people and coming out for the welfare of a nation, again we are not harming the transparency, and there is accountability at the side of government for AI throughout the review system and at the side of judges throughout the appealing system. So with following all the law, with the fairness, with the mandate passed by the government, we are not raising any concerns regarding to due process. If the bench don't have any questions for that, I would like to deal with the question asked by a bench earlier for the use of 38A and 39A for that matter. When we see that 38A and 38A and 39A, why it is connected to it, 39A says that states shall strive to promote the welfare of the people by securing, protecting, effective as it may a social order which justice, social, economical and political shall inform all the instructions of the national life. As we put forth that the aim is to provide a justice, and that's why we are coming with the law. The law has accountable, transparent, and law is being fair in its nature. So these conditions are fulfilled by the Bharat Nadu, and that's why we are arguing 38A. And moving to the 39A, equal justice and free legal aid. Apologies. And 39A, equal justice and free legal aid. For that matter, I would like to draw the attention of a court to the fact sheets para number 16. Fact sheet para number 16, which says, following the implementation of a Yuga Drishti, there was substantial reduction in administrative costs. The new system streamlined various facets of the justice process, from case management of a data analysis, resulting in a significant financial saving. This has allowed law enforcement agencies and courts to allocate resources more effectively, redirecting funds towards legal aid and welfare programs. And thus these two articles were connected to our case. If the bench don't have any queries related to submission, counsel
Yeah,
seeks
Mr. Counsel, your petitioner argued, so you are arguing that justice shall be done, being transparent, accountable. But the petitioners say that justice shall not only be done, but seem to be done. And seem to be done is missing in your law.
Sir, when we are saying that justice should be seen to be done, I guess they take the just subjective opinion of theirs. If you are following the fair trial which is granted by a law, if you are making transparency, if you are making accountability, we are not doing anything against the law. We are following everything by a law and providing a justice. The justice is seen to be done because everything is illegal in criminal justice system. The things to be seen as a done, the things to be followed by a law and managed by a law, and that is in our case, and that's why justice is also seen to be done in the case. And if there is end of queries from the side of judges, counsel for respondent like to proceed with the prayer.
The source of power, will you answer or you go counsel?
I will answer.
What is the source of power for this enactment?
As the law mandates, its fact sheets is
No,
Fact sheet will be there.
need not be there.
But law,
Power.
source of power to make this law.
From where have you drawn the power to make this law? Simple.
a state can make a law in a welfare of a country.
With reference to Schedule 7, do you have any answer? Schedule 7 to the Constitution. Take your time answering your survey.
Okay, I will answer it, Sir, and I will request to approve my prayer, and we will like to proceed with the prayer.
Without these answers, prayer is out of place.
So should we continue?
You reserve your prayer for the ceremony.
The council seeks permission to proceed with the rebutals. Firstly, your lordships, the pursuant to the submissions made by the council for the respondent, maintainability was supposed to be contested. However, it has not been contested. Secondly, the learned council argued that face recognition is allowed in India and the AI is in parallels to that. Your lordships, face recognition is mere automation. However, the AI includes machine learning. Secondly, questioned about the use of AI in other countries, the council had stated that Compass is one such technology and was analyzed in the case of Loomis vs. Wisconsin. Your lordships, the council has been partial in her arguments. Loomis vs. Wisconsin was the case that raised heavy concerns on the AI, your lordships. Also, as per the reports annexed in R2 and R3 by the counsel for the petitioner, the problems with the AI Compass are highlighted. Your lordship, in the council in incriminating blacks and Hispanics is clearly highlighted. Your lordships, substantiating further, HART is an AI used in UK which has substantial problems regarding data collection. Victor is a similar AI used in Argentina and Brazil, going rogue and bringing down the entire judicial system. Your lordships, it is high time we stopped importing foreign solutions and making them Bharat Nadu problems. Thirdly, your lordships, the council had adverted that para 12 of the moot proposition states that only persons who are priorly incriminated, their data is collected. However, your lordships, there are several people like those under preventive detention who are not criminals, and even the data of those who are providing security for bail, their data is collected, your lordships. Hence, it is not merely the accused, but a substantial part of the population, including those under pre-trial detention. Considering that the prisons in Bharat Nadu are overflowing, it encompasses a myriad factors and substantial part of the population. Further, your lordships, just because a body of experts were constituted to develop the AI doesn't imply equality, transparency, or fairness. It only implies technology, technicality, and technical illiteracy. Further, your lordships, myriad factors have been apparently weighed to arrive at a decision of the AI. However, there is no transparency regarding how those data is weighed. When the counsel for the respondent was questioned on the same, she just said that data is stored in clear-cut compartments and hence it is weighed with transparency. Your lordships, if such is the technical knowledge of the counsel of the respondents who is representing and defending an AI, then how can the other counsels be educated on the same, your lordships? Further, the counsel stated that the infringement of a right is mere hypothecation and is highly subjective. Your lordship, Annexure 1 of the moot proposition shows a clear instance where discrimination and prejudice have already begun, your lordships. Further, your lordships, moving on to the power to enact a law, your lordships, 7th schedule, Article 246, allows the respondents to frame a law. However, they were not aware of the same. National interest falls under entry 1 of the 7th schedule of the union list, and entry 1 of the state list includes public law and order, and hence clearly the respondents are empowered to enact such a law which they are clearly not aware of. Proceeding, your lordships, the council had quoted that GDPR states that the union shall only collect data based upon consent. However, the council is clearly unaware of the Digital Data Protection Act 2023. Section 30 of the Act allows the union to collect data without consent. The union is exempt for such act, and it is common knowledge that municipal law surpasses international law. Hence, the GDPR is not applicable in this case, and data shall be collected.
We are trying to accept most of your argument and part of their prayer. Say that we need AI, but with some filters, some modifications. 3 points. Can you suggest modification to that? Of course, as Sir said, Sir pointed out, that race, religion, caste, sex, all those things we can properly filter from the present information collection or analysis of the information collection. We are inclined to allow the AI to be a part of our judicial system, whether criminal or civil or whatever. Data is what we need to administer justice. Without data, it's like data coming from human beings, from robots, from artificial intelligence, doesn't matter from where it comes. So in 3 points, you want to suggest some changes to the existing law?
Your lordship, the
Each of us.
What is each of us?
the lordship, the council will contest.
Bullet points only, no content.
Indeed, your lordship, the council does not accept
Because your
the
time
use
is
of
over. We are extending our.
the use of AI, but in arguendo, if suggestions were to be posed. Firstly, anonymization of the data. Secondly, transparency of the data collection process should be monitored severely. And thirdly, procedural safeguards and to allow the surveillance of the algorithm to a select amount of people.
If these 3 are allowed to you, you are okay with the law being passed as it is?
Indeed, not your lordships.
Indeed?
Not your lordships.
Then?
The council will still advert that the use of AI is fundamentally flawed and affects the basic structure of the constitution by violating the separation of judiciary and executive, your lordships, firstly. Secondly, it impacts secularism, which is a part of a preamble, by inculcating race. And thirdly, it violates Article 14 and Article 21, no matter what changes are made. In arguendo, the council posed certain recommendations. However, even so, the AI is a hopeless cause, your lordships.
So at least you pronounce on the validity of this legislation, we don't have any artificial intelligence as that is our
The council seeks permission to retire.
Good.
it and ask the questions against the law. If it is maintainable or not, it's not a question because it's not an issue framed in a fact sheet also. And maintainability, we are not arguing against it because it's maintainable, we are agreeing it. But the questions and the concerns raised according to the unconstitutionality of the law is not maintainable. That's we are here to argue. Now answering some
The
main
first one, source of power, we still want you to tell us which entry in the list, any of the three lists is the source of power. Though your counterpart admitted to the source of power being there, she was not clear which power, where, which entry.
Which entry in the list?
entry first, public law and order, schedule 7 and also article 2 to 6.
Schedule 7 entry?
Which list?
Which list?
Concurrent list, public law and order.
I don't see such an entry in the concurrent list.
Just give the entry number.
What you are looking at is second list, state list.
Council plead ignorance because it's running.
You admitted, with our permission you can answer. Which entry, which list?
Entry 1 of Union List, National Security.
Read the entry one. Every criminal case is not about national security.
You said entry 1, list 1.
Your Lordships, however, a single entry might not be the source of a legislation. It consists of various entries and the Council has quoted one, Your Lordships. And since the
So
respondents
what are various entries? Which various entries?
shall the Council revert back, Your Lordships?
When? Okay. We had a good time.
It's all
Where?
to argue before this.
Where? What's the where?
We would like to start with the prayer. Therefore, in the light of the facts of the case, issues raised, argument advanced, and authority cited, this is submitted before the Honorable Court may be pleased to declare that the use of AI algorithm in the pre-trial detention decisions, bail hearing, and sentencing does not violate the right to fair trial guaranteed under Article 21. The use of an AI algorithm to predict criminal behavior does not violate the right to equality guaranteed Article 14. The use of AI algorithm in criminal justice making does not raise concerns about transparency, accountability, and due process guaranteed under Constitution of Bharat Nadu, and use of an AI algorithm to predict the criminal behaviors does not violate the right to privacy guaranteed under Article 21 of the Constitution. Any order passed in favor of justice will be accepted from the side of respondents. It's pleasure to argue.
Now I request team ushers to kindly escort your team towards the
Just
back.
for me, just for me. You are a teacher, you are a teacher.
Sir, now the scoring will be done. Kindly take your
What I
leave.
thought was,
Yes.
I have no feedback for your performance. Generally, as to how you should go about is all that was. You see, some larger issues. Please focus on the relevant issue. Don't overlap. It leads to confusion. Secondly, it has been my experience in all moot courts. The issues that are found in the fact sheets are totally different. Rather, they are not that you find in your this is one thing. Then, first refer to the statutory provisions, whether it is moot court or regular court. Then, the last thing is, you should keep this basic procedure of us. If a moot proposition leading to a civil law, CPC, CRPC, evidence. Keep it. That's all. I have nothing more to say.
One more if I may add. AI, of course, so many things have now become abbreviations. It was public interest litigation, then it was PIL, now it has become a PIL. So avoid these things. It goes into the lexicon and everyone starts PIL. Because it may have some other meaning also otherwise. That's all.
I can say splendid was my day today because I got the opportunity to sit here and see all of you so well prepared. The questions we put to you was only for the purpose of understanding your ability to withstand adversity. I am a lawyer, practicing lawyer. I still dread every day before stepping inside court hall. I appeared before His Lordship. He was very courteous, he was very polite. In spite of it, I was dreading myself, stepping into any court hall. Even today, tomorrow, Monday, I have to argue some cases, so I still am worried about those things.
Well, you can take assistance of some of them.
Definitely. But the kind of preparation that you have, the questions that we were putting to you is only to see the preparation is all there. It's all here. You have probably worked day and night, you worked hard, you have done well. You have the language, probably you have the AI also to help you prepare all these things. But still, again the human interaction, the questions which were put were to understand your ability to withstand adversity, which is whether you are a lawyer, you are anybody. We have teachers here. Sir also teaches in judicial academy. He teaches judges. He was a judge, retired. He teaches judges. So, with that, any place outside this college, you have a wonderful atmosphere here. You have a family atmosphere here. The moment you step outside from here, the outside world, the profession, whatever you choose, the first thing that you are going to face, encounter, is adversity. So in all adversities, the manner in which you conduct yourself upon facing adversity is going to decide whether you are going to continue to face adversity or going to make the other competitor, the counterparty, the other person across the bench, across the table, your friend, your family, how you keep smiling in spite of the question and tell me not to ask the question or to answer my question, however nonsensical it was. We didn't read this before we came here. You have taken at least the minimum. The sir was saying it takes about half an hour to prepare these kind of things and with the use of AI. Minimum you have taken half an hour. Worst case scenario. Blaming you for not preparing. Half an hour you have taken, but still you have taken some amount. We have not taken. We probably. I will not speak for my learned brothers here, but I was probably asking nonsensical questions. But in spite of it, the manner in which, with a smile, all four of you, and I'm sure your support team was supporting you with those the answers or to fill in confidence to you. That is very important. I enjoyed every bit of my sitting here. Thank you for making this day good for me. You have prepared well, all of you. There is absolutely no non-preparation. As sir said, we are not going to be able to judge you for the kind of preparation that you have done. Anyway, we have to give one more
experience in the principle.
That's all.
And okay. My side,
good luck and
from my side, it's special day for because it must be perhaps the 25th we have to give them feedback. He is a public prosecutor and also a defense lawyer and also a civil lawyer. Before we appeared in a civil case. Well, I was a lawyer for some time. because of my own passion, I go to Law College, I go to Judicial Academy. I have by my side. I had an occasion to sit with a lawyer and an academician sometimes. But today is a situation where I have both an academician and a lawyer who incidentally is also a public prosecutor. I have enjoyed a very bit of my stay here. Good luck for your future. Don't worry about this. Still, but we only have a request. We see bright law graduates only in the good course. In the regular course, it's a problem for us. We are not able to hear this good English, this preparation. You feel happy about this. So it is something for him to see that these bright people also at the big course.
Now I request Ms. Zenia, Assistant Professor of KLE Law College Bengaluru, to please introduce our honorable judges to the participants as well as to the audience.
Thank you, Ms. Sikra. A very warm good afternoon to the distinguished judges, to the August gathering and the semi-finalists. I'm Ms. Zenia, Assistant Professor, KLE Law College, Bengaluru. I in fact deem it my privilege to introduce the esteemed judges for the day. We have with us Professor Dr. V. Sudesh. Professor Dr. V. Sudesh is a distinguished alumnus of Bangalore University. Dedication to the legal profession, he practiced law from 1993 to 1998. Professor with over 28 years of teaching and research experience, specializes in labor laws, intellectual property law, and jurisprudence. Notably, Professor Sudesh has successfully guided 11 students at the doctoral degree level. Professor has served as an ex officio member of the Karnataka State Law Commission. Professor's expertise has led to his invitation as a resource person by the UGC, Human Resource Development Center, as well various universities. Sir has an impressive list of publications which speaks, in fact, volumes of his scholarly achievements. In the administrative realm, Professor Dr. Sudesh has held key positions, including officiating as the Vice Chancellor of the Bangalore University and serving as the Dean of the Faculty of Law, Chairman and Principal at the University Law. Currently, Professor Sudesh serves as the General Secretary of the University Law College Alumni Association and holds position as a Professor of Law and Chairperson at the University Law College. It is indeed an honor to have you with us, sir. I now proceed to briefly introduce Shri S.R. Somashekara, sir. Shri S.R. Somashekara, sir, practiced as an advocate from 1979 to 1985. Sir joined judiciary in 1985 as Munsif, and after serving in various cadres, retired as the Principal District Judge, Bengaluru Rural District. After retirement, Shri Somashekara, sir, served as a resource person in Karnataka Judicial Academy. Pardon me, sir. Pardon me. Serving as a resource person in Karnataka Judicial Academy, participated in several training programs and workshops organized by the Legal Services Authority, the Bar Council of India, and several bar associations. Sir has also been part of a number of programs that caters to candidates taking up district and civil judges examinations. Sir has judged moot court competitions on various occasions, addressed law students and other students as guest speakers in numerous law colleges across the country. In addition, Sir adorns the position of an arbitrator on the panel of arbitrators of Karnataka, High Court of Karnataka, and has successfully completed a few private arbitrations. Sir, it is indeed an honor to have you amongst us. I now proceed to briefly introducing Shri Venkatesh R. Bhatti. Shri Venkatesh Arbati has worked in various fields of law and holds an expertise in many facets of the legal profession. Sir is presently a partner at the KLE Law Partners. Sir has rendered his valuable contribution to PM Vasudev and Company. Shri Venkatesh Arbati sir holds a degree from the Institute of Company Secretaries of India and is thus an expert not just in law but also in compliance. Shri Venkatesh Arbati sir has completed his education from the Bangalore University and is a virtuous legal expert in the fields of criminal law, corporate law, commercial litigation, arbitration, intellectual property, dispute resolution, competition law, international arbitration, licensing, copyright law, among several others. Sir, it is an honor to have you amongst us. I sincerely thank the esteemed judges for their valuable contribution in ensuring the successful adjudication of the semi-final rounds alongside their incisive insights. Thank you.
The city like Bangalore, expecting lawyers to practice both on the civil side and the criminal side is a rarity. All parts it is possible. And credit goes to the he appeared before me in a civil case.
Thank you.
Thank you so much, ma'am. Thank you, judges, for your presence, precious time, and cooperation. It was an honor to have you all here. I would also like to thank our participants. I hope you all had a great experience in the 6th edition of Surana and Surana National Constitutional Law Book Court Competition 2023